Sean, are you there?
Yes, Judge, I'm here.
So are we all set? Do we have court reporter and both attorneys?
The court reporter is here, and
Wait, you're muted, I think. I don't hear
I'm
you.
sorry.
Mhm.
Can you hear me now?
That's odd.
I could hear you, Sean, just so you know.
Okay, thank you.
Yeah, this is Chris Ryan. I could hear you as well, Sean.
Sean, should I back out and come back in?
And Sean, just so you know, I think we're waiting on an attorney from Health West is planning to appear, and then maybe one other person.
Okay, thank you.
Yeah, and I believe Miss Halloran from my office will be joining as well.
Okay, I will promote everybody when I see them in there.
Thanks.
Judge, can you hear me now?
No.
I can hear you, Judge. Can you hear me?
I am.
Can anyone see or hear the court reporter? This is the second. Okay, there, I can see myself. Can you see me?
I can see and hear you.
Okay, because I could not get a picture, nor could I hear. I could hear you guys, but I don't think anybody could hear me before.
I couldn't hear you before if you were speaking.
Oh, I was.
Okay.
So I need to know who everybody is and who represents what here. So I have Judge Shapiro is the judge, is that right? Or now I don't even see Judge Shapiro. Okay, first off, who is Mr. Kavanaugh? Who are you representing?
So I represent the defendants in this matter. So State of Michigan, DHHS, and then Director Elizabeth Hertel. And then my colleague, Kate Halloran, represents them as well.
Okay, Kathleen. H.A. Okay. So DHS, State of Michigan, and you said somebody else.
Elizabeth Hertel.
Okay, because I have only caption I have is Lakeshore Regional Entity versus State of Michigan. So if this is going to be produced, I'm going to need an actual caption. And Christopher Ryan, who do you represent?
Lakeshore Regional Entity, and my partner Greg Moore is on as well.
Okay, hold on. Christopher Ryan. And then I have a Sean. I can't pronounce the last name.
Sword.
Sword. Who do you represent or what's going on here?
I'm just hosting for the Court of Claims.
Okay. All right. And then I think Sarah, who are you? And
good morning, Sarah Gabus here for intervening plaintiff, Muskegon County and Health West.
Okay. All right, and then do we have the judge on yet? We
I think
have
he
a
was having
contract.
some technical difficulties.
Okay. All right. He has technical difficulties. I had technical difficulties.
Yeah, it happens.
Besides a bad hair day. It's a Monday, that's for sure. I think my problem was I didn't click fast enough for join as panelist. And I think that may have been where my problem was. I think if you're not a panelist, you don't get seen or heard. So I have done motions for Court of Appeals in person. I have not done them by Zoom. I do not know if this is something anybody's going to want produced, or usually the motions don't get produced. Usually the court doesn't want them, but I don't know about anybody else. Maybe it'll depend on what the finding ends up being.
I suspect that's probably true.
So let me know before you sign off if you do want a copy of it. And of course, I'll ask the court before the end of it too. And if anybody needs to know, I am with Hanson Renaissance Reporting.
We could always order it at a later date, correct?
You can at any point in time. I keep them for, it's supposed to only be 5 years, but truthfully, I have them for about 20 years before I get rid of them. Although I will tell you, somebody once requested a transcript that was 32 years old and I couldn't find it. And it was on a machine that I couldn't even access anymore. Didn't even have the software to access it anymore. I thought that was a little strange, 32 years. If everybody will excuse me, I'm going to step away for a moment and get some more coffee. I'll be right back.
All right. Good morning. Can everybody hear me?
Yes, Your Honor.
Yes.
All right. So hold on a second. Okay. Very good. And do we have everybody? We got a
I might
big
count,
crowd.
yes. Judge.
Is there a Mr. Moore who's expected to join?
Yes, I'm here, Your Honor.
Oh, very good. Okay, very good. All righty. Well, this is quite a case. It made for interesting and difficult reading. So I'm going to call the case, and then I want to say a couple of things before we get started. So this is cross motions for summary disposition in Lakeshore Regional Entity versus State of Michigan DHHS et al. And number 22-146 MK. Plaintiff filed a motion and defendant responded with a cross motion or a counter motion, excuse me, and we ended up with about 8 or 9 briefs. And so, am I correct? Well, is there? Tell me who can I address primarily on which side with a couple of questions.
Sure. I'll be speaking primarily for Lakeshore.
For Lakeshore, Mr. Ryan and Mr.
Correct.
Kavanaugh?
Yes.
For the
I'll
state?
be speaking for the state, Your Honor.
Very good. All right. It seems to me there are 3 areas, and please correct me. One is what the contract says. Another is what the settlement and LRE proposal and various documents to resolve the deficit say and whether they're relevant. And third, whether there are some statutory regulatory issues out there that may be relevant. Is there another major area I'm missing?
I don't believe so, Your Honor.
Okay.
No,
So the first thing I want to direct the parties to provide me in 7 days, if possible. You tell me if you need more. I need a glossary. And I'll read you the things that I need to find. And if you can't agree on a definition, then you'll have to submit 2 separate ones. And I'll put this in an order so you don't have to, memorize them now. But the terms I have written down that I'm still confused about, even though they're central, are surplus funds, Medicaid savings fund, internal service fund, primarily, I think I understand it, but primarily what money goes in there, risk corridor, reserves, RMS, FSR, and benefit stabilization. I do not have accounting experience, and these terms are not familiar to me. And of course, public benefits law is always very confusing. So having said that, we can just proceed with the plaintiff first. And if you would take whatever time you need, I may have questions, and we'll hear from the state. All right. So Mr. Ryan.
sure. Thank you, Your Honor. So, I mean, obviously the court recognizes these motions have been briefed extensively. I just want to highlight a couple of things and then take whatever questions that the court might have.
Okay.
This all started, obviously, the state has a constitutional mandate to provide behavioral health services to citizens of the state of Michigan.
Mm-hmm.
Lakeshore helps facilitate those services in 7 different counties in a particular region of the state. The way that the state carries out its obligation to provide these services is by contracting with entities like Lakeshore, my client, who is it's called a prepaid inpatient health plan. That's a PIHP.
It's not relevant, Mr. Ryan, but is it a profit agency? Is it a nonprofit? Is it? I don't really understand its nature.
Yeah, so that's a good question. And my understanding is it's none of those really. It's sort of a creature of statute. Within the statutes, there is the creation of this PIHP entity. So it's not like a LLC or a corporation or something like that. It's sort of a different creature. And essentially what MDHHS does is it pays Lakeshore these capitated payments based on the number of Medicaid recipients in the region. And then Lakeshore actually contracts with what are called community mental health organizations at the county level to actually provide the services to the citizens of the state. And so, make a long story short, back in 2018, 2019, there was a pretty significant funding deficit from MDHHS to Lakeshore. That in turn prevented the CMHs from receiving full funding. Eventually, that methodology for funding Lakeshore was corrected in 2020, and all told, that deficit resulted in about $30 million shortfall that currently is being held at the CMH level. They're the ones that are ultimately out this money right now.
And did this occurred in 17 and 18, the deficit?
It was fiscal years 18 and 19.
18 and 19, okay.
So that deficit, as we kind of alluded to in our brief, there's been a flurry of litigation kind of all over the state in different forums with different parties.
Right.
There's a lawsuit filed by Health West, who's represented here today, against Lakeshore, claiming that Lakeshore is responsible for the money. Health West sued the state of Michigan in the Court of Claims. That issue is on appeal. Again, they're claiming they're responsible for payment of the money, that the state is responsible for payment of the money. There's been administrative actions that are kind of related to the deficit, appeals to the circuit court, et cetera.
Right, and I think that case is being heard next month in the Court of Appeals.
I believe that's right. Yeah, Lakeshore was originally involved in that case. We were dismissed early on, so we're not involved in that directly any longer, but I think that's right. I'll let the attorneys for Health West address this in a little bit more detail, but it's ironic. I think one of the arguments that the state is taking in that case is that that Health West should be seeking reimbursement for the deficit, not from the state, but from Lakeshore. And obviously in this case, they're saying Lakeshore's not allowed to reimburse them from the deficit. So it's a little...
well, let me stop you there again. I'm sorry I keep interrupting, but...
No, it's okay.
So what source of monies does LRE have? Is there anything other than these capitated payments that comes into the pool of money that it then pays to the CMHs?
Nothing meaningful. Is my understanding that there may be a fraction of like very small percentage that comes from some sort of grants that aren't part of this, but the overwhelming majority is, yeah, any money that we've got, meaningful money that Lakeshore has, comes from the capitated payments from the PIHP contracts. So over the last few years, while all this litigation is ongoing, there has been a concerted effort on Lakeshore's part to position itself so that it could be able to address that historic deficit. Setting aside who's responsible for it, Lakeshore is now in a position where it has the means to be able to pay the deficit. It has the desire to pay the deficit, and it's outlined why Lakeshore believes that we're able to do this, either through use of the ISF funds, use of Medicaid savings, or use of just current capitated payments that are left over after payment of services. And the state's position is, if you do that, you're going to be in breach of the contract. So, sort of at a crossroads, do we take the action and risk liability of a $30 million breach of contract action, or do we file this action in the Court of Claims and let the court decide, does the contract permit it or does it not? Obviously, here's where we are. So before I get really into the details of the contract, there's a practical element to all this. Number one, obviously, as I alluded to, there's litigation pending all over the state. All of that becomes moot. If Lakeshore can pay this and does, then the litigation between Health West and Lakeshore becomes moot. The litigation between Health West and the state becomes moot. All of that goes away.
Mm-hmm.
And second, one of the paramount reasons for why Lakeshore wants to pay this deficit is it will add tremendous stability to the population that is served by these CMHs. These CMHs are currently holding the bag for this multi-million-dollar deficit. If we can pay that, it will add financial stability to those CMHs. It will help continue to ensure that services are rendered to the citizens of the state that actually need these behavioral health care services. And there's also, I think it's worth noting that if the state's interpretation was right, what it would practically mean is that no money is ever eligible for funding services rendered during a prior year, which would essentially mean Lakeshore and these CMHs could never just recover from any sort of yearly deficit. Deficits are bound to happen in any given year, and if the state's interpretation is right that no money can be used to fund those prior deficits, there's just no way to recover.
Well, the notion, I assume, is that the ISF is there as a reserve. So if you have a deficit, you can make it up out of that. But in this case, we have a depleted ISF, right?
We did, and until
That's what I mean. At the time, you had a depleted
yeah,
ISF.
in 18 and 19, correct. The on the books there was a negative balance to the ISF. You know, it's been described to me as sort of like a wave. It's going to have peaks and troughs, and over time the ISF should about balance out. But some years you're going to have a deficit, some years you're going to have a positive, and you know you can kind of true it up, so to speak, as able. So obviously the court summarized, we filed a motion for summary disposition as the plaintiff. Essentially, here's the contract. We believe we're allowed to do this. The state's taken the opposite position. So the state's position really, I think, is important because what they're essentially claiming is if we take this position, we're going to be in breach of contract. And so I think, you know, I acknowledge there's a burden on the part of Lakeshore to establish entitlement to summary disposition, but I think it's incumbent upon the state to say, look, if you're the one claiming that we would breach the contract by taking this action, show me which provision of the contract we would be breaching. And so I think there's a burden shifting that's important, that it's incumbent upon the state to meet its burden. I addressed this in the briefing. I won't go into it too much, but the state did attach some affidavits to the briefing, which I don't think are appropriate for the court to consider. Everybody thinks the contract's unambiguous, so the court shouldn't consider any extrinsic evidence in the face of an unambiguous contract. To the extent that the court does determine there's an ambiguity, our position is twofold. Number one, it has to be interpreted in favor of Lakeshore because the state wrote the contract. And number two, if it's not resolved in favor of Lakeshore and there's still a question of the court's mind, then obviously that's an issue for discovery. Go ahead.
I was going to say, you could go ahead and speak directly to the relevant contract provisions. I know it's in your brief. It would be helpful.
So overall, what this contract says is we're giving you these capitated payments, and the restriction, if you want to call it that, is that you got to use these payments to fund Medicaid services for Medicaid beneficiaries. And sort of overarching all of this through the various methods that we're proposing, that's what we're trying to do. We're trying to pay this deficit that is made up of Medicaid services that were performed for Medicaid beneficiaries. And it's interesting in this case that there's no dispute over that. I mean, the state's not taking the position that these weren't Medicaid services performed for Medicaid beneficiaries. I think what's important is every one of the arguments that the state is making in response to our motion is almost assuming that the contract says the money has to be used for Medicaid services performed for Medicaid beneficiaries during the current fiscal year. And that language just isn't in the contract. And I think that's the important point underlying all this. So our first proposal was using funds that are in the internal service fund to satisfy the historic deficit. And that's really the entire purpose of the internal service fund, as the court, you know, alerted to earlier.
Let me stop you for just a second. How is the ISF funded?
You over time?
Well, I mean, obviously some monies must go in there. Where do they come from? And
Sure.
who puts them in?
Sure, I understand. So the PIHP contract, after there's a kind of a cost settlement process at the end of every fiscal year, and the contract contains certain provisions that allow a certain amount of money that's left over, so to speak, excess funds, to be put into the ISF. So ultimately, the money comes from the capitated payment.
Okay. Thank you.
Sure. And so, as the court can see in the briefing, what Lakeshore did is submitted financial status reports that accounted for that deficit exactly as permitted by, we've been referring to it as GASB 10. It's the Government Accounting Standards Board, GASB 10. And what it showed, as I said earlier, is that the ISF had a negative balance during fiscal years 18 and 19. Over the last 2 years, we've been bringing it up into positive. And now we're trying to, you know, true it up and pay that amount that for the years that it was negative. The state's argument is that the contract restricts use of the ISF to expected future liabilities, and that argument fails for two reasons. Number one, the word future appears in one section of the contract, but not in another. And where it appears is in the risk corridor section of the contract, not the provision of the contract that governs use of the ISF. So I think
Let me
that's
stop.
important. Sure.
What the heck is a risk corridor?
So the risk corridor is sort of the term of art that the parties use for it. There's a funding amount in the contract. I think it's, I don't remember exactly what it is. I think it's like $300 million is the total value of the contract. And I could be wrong on that, but for illustration purposes. The contract says that for liabilities that exceed that amount.
I'm going to stop you, Mr. Ryan. Are you telling me that the risk corridor is the plan of payment for unexpected deficits or expenses? That corridor is a term of art that just means this is how we're going to do it?
I believe that's right. Up to a certain amount. Yes. Up to, I think it's Lakeshore pays for half of the liabilities that are up to 5% above the contract value and 100% up to 110% of the contract value. And then everything else there.
I think it's the other way, but that doesn't matter.
You might be right. I might have misspoken.
Okay, so that helped. Risk corridor basically just means here's the plan for risks.
Yes.
Okay.
Second, I think even if the word future did appear in the section that governs the ISF, using the ISF to meet expected corridor requirements is exactly what we're trying to do. So year by year, Lakeshore charged the deficit to the ISF because the ISF didn't have any money in it. The balance was negative. And that's perfectly permitted by GASB 10. MDHHS isn't even disputing that it was proper method of accounting. And by crediting that ISF year over year, we were using the ISF to meet expected corridor requirements. And so now that we can finally settle up, that's when MDHHS is now objecting.
Well, how do you view the use of the term future in the risk corridor provisions? I mean, what are we to do with that? It says, the defined purpose is to secure funds necessary to meet expected future risk corridor requirements in accordance with whatever. Is it your position that it's surplusage or that future risk includes past damages that have piled up? Not damages, debts. I mean, you got to deal with that term.
Sure. So I think it's twofold. Number one, I think the fact that it only appears in the risk corridor section of the contract is telling that it doesn't appear in the ISF. So the purpose of the ISF for purposes of risk corridor is it takes into account the word future. But as I said, I think the Lakeshore was attempting to meet expected future risk corridor requirements by doing this, because if you look at back in, the FSRs, the financial status reports for fiscal years 2018 and 2019 account for this deficit in the ISF. It shows this negative balance. That's the way to account for the future risk corridor requirements. So in other words, if the ISF can never be brought back into positive, there is no way to account for future risk corridor requirements. If our ISF always remains negative, how are we to pay deficits into the future year?
So the deficit is charged pursuant to accounting principles to the ISF?
Correct. That's what the financial status reports show.
Okay.
Yeah. So that's really kind of the summary of the argument on the ISF is it incorporates GASB 10. GASB 10 permits using this exact method of accounting, and GASB 10 permits it. The second proposal for being able to pay the deficit is to use current capitated payments that are left over after Lakeshore pays for medical services that are rendered during the current fiscal year.
Okay,
again,
is that called surplus or Medicaid surplus or something else?
So I think the court's hitting on an important point. And I think, so in our motion for summary disposition, we were using the term surplus as sort of a a generic term for money left over. I think when the state then filed its response and said, well, no, the surplus has to be returned to the state. Now I think it's important to then define, well, what do you mean when you're talking about surplus? And I think we're talking about two different things here. There are what I'll call excess funds is the funds that I'm talking about here. Excess funds are funds that are remaining in a year after services for the year are funded, but before there's any money added to the ISF, before there's any calculation about amounts that might have to be returned to the state, the contract allows, specifically allows use of that money to fund other services in other categories. And now surplus funds.
Is this where it says you can do the Healthy Michigan and Medicaid? Okay, but tell me why that helps you in terms of whether or not you can use it.
Because that provision of the contract says we can use funds that are excess funds in those accounts to fund other Medicaid services. And what it doesn't say is what the state's trying to argue. The state's trying to argue, well, it says that you have to expend those money for services rendered during the fiscal year. And that's not what it says. It says you have to expend the money during the fiscal year, but that's exactly what we're trying to do. We're trying to expend the money.
What would normally happen to surplus funds? Let's assume your ISF is healthy. What happens to surplus funds then?
Well, again, I think it's important. I would ask the court which funds are we talking about? Because I don't consider the funds before funding the ISF and things like that to be surplus. They're excess, but the surplus funds that the state is referring to is after funding of the ISF, after all of the cost settlement and everything, what's left over. And that's the important distinction, because the excess funds, the contract specifically allows them to be used as long as they're used to fund Medicaid services for Medicaid beneficiaries. And again, I'll reiterate, what the contract does not say is that those funds have to be used for services rendered during the fiscal year. Could have said that, but it doesn't.
Can you point me to a contractual provision that's relevant to what you're saying now?
Sure.
Because I got a lot of highlighting here and I'm not sure which.
Yeah, understood. I guess page. Oh, let me just look up just to be sure.
Take a minute.
So it's at the very bottom of page 69 and the top of page 70. And again, I think the contract it's not a defined term of quote unquote surplus funds, but what it says is the contractor may expend any funds received for MMSSSP, which is a defined term that basically refers to that the largest chunk of money. All funds must be spent on Medicaid beneficiaries for Medicaid services. Surplus funding in either Michigan or Healthy Michigan may be utilized to cover a funding deficit only after that fund source's risk reserve has been fully utilized. The surplus funds must be used before the ISF can be utilized. So that's the point is.
We got three categories here. We have surplus funding, ISF, and excess fund, although that's not in here. Okay, so go ahead, continue, I'm sorry.
So the important part is it doesn't say all funds must be spent on Medicaid beneficiaries for Medicaid services that are rendered during the fiscal year. That's just language that the state is their argument sort of reads that into the contract, and it doesn't say that. It's exactly, there's no dispute. What we're trying to do is fund Medicaid services rendered to Medicaid beneficiaries. So that's why we believe that the current capitated payments can be used for that purpose.
Can you talk a little bit about the seemingly conflicting contractual provisions, which I can't name at the moment, one of which says you spend the ISF first and one of which says you spend something else first? Do you know what I'm referring to?
I believe so. And again, I think this gets back into the sort of semantical debate about no matter what you call excess funding or what you call surplus funding, we're talking about money left over at two different points in time. One of them is before funding of the ISF, before cost settlement and all that. The other is after all of that takes place, after funding of the ISF, after cost cost settlement, et cetera.
Okay. Confused. That's okay. Anything else you want to say about the contract? And let me look at my notes here. And then I'd like you to talk some about the settlement and the regional entity risk management strategy issue.
Sure. Just a second.
Are you waiting on me?
No, I'm sorry, I'm going over. So our other argument for why current funds can be used is because current dollars can be used as part of a risk management strategy, which the court just hinted at. We submitted our risk management strategy to the state. Actually, I think it was 1 year and 3 days ago. And right in there, it says Lakeshore may use current surplus to settle the historic deficit. And it was approved. They issued an approval letter. We attached it to our briefing that says it's found to be in compliance. And now their argument is, well, Lakeshore just kind of snuck in the fact that it's going to be using these historic, funds to pay historic deficits. And I just want the court to be clear. We attached the risk management strategy to our briefing. It's not like a 400-page document where a single line was snuck in. The whole document's only 3 pages.
No, and it's, but it was not part of the settlement agreement. It was later, correct?
It was the risk management strategy, correctly. The settlement agreement was something that was addressed by Health West in their concurrence. That wasn't part of our briefing. When we're talking about the risk management strategy, that's part of the yearly kind of obligations on the part of Lakeshore is you got to submit these risk management strategies. We did it. One of the categories addresses this topic, and we said, this is what we might do with this money. And they said, okay, that's approved. And now they're saying, well, we didn't see it, or I'm not really sure what the argument is.
Let's assume for purposes of argument that the contract forbids you from doing this. Does the acceptance of the management strategy trump that?
I'm not following which management strategy.
Okay. The Lakeshore Regional Entities 2022, the 3-page document or the 2-page document that was approved on March 29th, 2022.
Yeah, I mean, I think you're
going to pay the historic deficits.
Sure. So you're saying arguably, even if the contract did prohibit it, does the fact that Lakeshore said it might do it and the state said, okay, trump that?
Exactly.
Yeah, I think it would. It would essentially operate as either a waiver or an amendment to some extent to that provision. But at the end of the day, I think the contract says we can do it we can use the current surplus or current excess funds, I should be more precise, in accordance with the risk management strategy. And we said we're going to do it, and they said okay. So I do think that the contract allows it.
Okay.
So the last piece is about Medicaid savings, and that's we've got these 3 different ways that we think we can use it. The last one's Medicaid savings. And the current PIHP contract doesn't contain any restrictions whatsoever on Lakeshore's use of Medicaid savings. There was some limiting language that was in prior versions of the PIHP contract, but the state overhauled the contract a few years ago, removed it. And as we set forth in our supplemental briefing, the state's now saying, well, we omitted it in error, and they're trying to put that language back into the contract. But here's the important piece. They're not just trying to put the language from 2019 back into the contract. They're trying to add something in there saying Medicaid savings funds can't be used to fund a historic deficit. That language has never appeared in any version of the contract. They're just trying to add it in now. And I think the important part and the reason that we wanted to file that supplemental brief is by insisting on this amendment, which they're saying is non-negotiable, you got to sign it. They're essentially admitting that the current contract doesn't contain any limiting language for Medicaid savings. Otherwise, what's the purpose of the amendment if it already prohibits it, as they say? So that's why we wanted to file the supplemental brief, and we appreciate the court giving us the opportunity to do that.
So tell me what Medicaid savings are.
It's another form of savings that can be used for different purposes, including if you look at the 2019 contract, which did discuss Medicaid savings and contained some restrictions. One of the purposes was to provide benefit stabilization. And what that essentially boils down to is, expending funds to ensure that funds can continue into the future. And as I said at the beginning of my argument today, that's one of the reasons why Lakeshore wants to pay this, to provide that financial stability and ensure that these CMHs can continue to provide these services.
But I need a little more detail. Where does the money come that is called Medicaid savings? Where does it come from?
You mean in terms of the capitated payment that it comes from?
In terms of anything, you say there's money called Medicaid savings. You told me a little bit about how it may or may not be used, but you haven't told me how the money becomes Medicaid savings.
Ultimately, it's from the capitated payments from the PIHP contract.
So it's money that's in excess of what had to be used that year.
I believe so.
And how does that differ from what you've called excess funds?
Well, because the calculation of what goes into Medicaid savings happens after all of those services have been provided, after all of the funds have been used to the extent that they can on Medicaid services.
Including ISF payment?
So my understanding is that after that amount, after all the services are actually paid for, the administrative costs, things like that, then there's a calculation based on whatever money is represented by that amount. There's a calculation of a certain amount can go to ISF, a certain amount can go to Medicaid savings. And the purposes of those are different, right? Medicaid savings you can use for some things and not others. ISF you can use for some things and not others.
And is that set forth in the contract?
Well, so here's the interesting thing. It was set forth in the 2019 contract. The current contract, as the state points out, the state tries to say, well, there's no provision even allowing for use of or allowing for Medicaid savings at all. But they attach these worksheets that they say become part of the contract that talk all about Medicaid savings. So I don't think it's a legitimate argument to say there's no such thing as Medicaid savings anymore. Well, at the same time, there's worksheets that discuss it that they say are imported in the contract. And number two, they're trying to say that the language was inadvertently omitted from the contract. And again, I addressed those worksheets in response to the state's motion, but those worksheets don't say anything about being utilized for services rendered during the current fiscal year. They talk about costs, that are expended during the current fiscal year, but they don't talk about being restricted to services rendered during the fiscal year. So I don't think those worksheets help the state's argument at all.
Am I looking at the right contract? The one I'm looking at, I think it was Exhibit A. It's dated October 1 to October 30, 2020.
Right.
October 31. Is that the right contract I'm looking at?
Yeah, and I believe it's the same contract that's just been extended.
Okay. All right. Okay. If you have more, go ahead. Otherwise, we'll turn it over.
Yeah, the last point that I think I need to address is the federal and state law. I think if you agree with the state's interpretation of the contract, that they're allowed to say where these funds can be spent, how these funds can be spent, it violates the statute, the Code of Federal Regulations we cited. It's 42 CFR 438.6, which prohibits the state from directing the PIHP expenditures under the contract.
Can you show me where? Hang on. This is the CFR. It looks like I didn't copy it. Shoot.
So it's page 13 and 14 of our motion.
Okay.
Talks about the state may not direct Lakeshore's expenditures under the contract.
Page 13 to 14, you said? Okay.
Yes, and I'm sorry, I was looking at the wrong document. Let me pull it up. It's actually page 17 of our motion. I was looking at the reply brief. I apologize.
Okay.
It says the state may not direct the PIHP's expenditures under the contract. And when that became final, if you look at the Federal Register when they're discussing implementing these regulations, it wasn't like it was something new. It was a long-standing policy that discussed whether or not the state's allowed to restrict expenditures under the contract, and they historically have not been able to do so, and this just codified that policy. So I think, you know, it's important at the end of the day, Lakeshore is trying to use these funds to pay for Medicaid services. They were rendered to Medicaid beneficiaries, and there's nothing in the PIHP contract that restricts Lakeshore's ability to do that simply because those services were rendered during a prior fiscal year.
Okay. All right. Let's hear from Health West.
Good morning. Thank you, Your Honor. For the most part, we would concur in Mr. Ryan's argument as it relates to the ability of Lakeshore Regional Entity to pay the historical deficits with their Medicaid savings, ISF, and current funds. What I would like to point out for the court as it pertains to the practical effect of what has happened here is that Health West, a community mental health service agency, has been left holding a $12 million bag, essentially, since 2019. What has occurred was, whether it was an inappropriate capitated appropriation that the state had made through their Milliman agency, whether or not that was an appropriate determination of capitated amounts, whether they incurred a funding deficit, whatever the case may be, there was a deficit in the amount of funding provided for community mental health services that has left Health West and Muskegon County holding $12 million. And Muskegon County and Health West are not the constitutional or statutory entity that is mandated to fund those services. That is the state of Michigan that is constitutionally mandated to support it and statutorily required to fund it. And what has happened is the state has said, sorry, in the Court of Appeals case that was alluded to earlier, the state has said, sorry, it's not our obligation. You have a contract with Lakeshore. Go get your money from Lakeshore. And what the state is now saying, now that Lakeshore is indicated that we have enough money to resolve the deficit in our internal service fund, it's appropriate under the accounting principles mandated in the contract for us to resolve the deficit in the internal service fund this way and pay for the Medicaid services that were provided in 2018 and 19.
I'm sorry.
Now the state is saying, nope, sorry, Lakeshore, you can't pay it. So where does that leave Muskegon County and Health West and Network 180 and all of the other CMHs that have been left holding this $30 million deficit? Where it leaves them is in an unstable environment, in an unstable condition to continue to provide community mental health services to their very needy population. I can't understand why any county would undertake this obligation if the state is permitted to speak out of both sides of their mouth, so to speak, as it relates to this issue.
Let me ask you, and of course, Mr. Kavanaugh may speak to it, but has the state indicated to you in that other case how the LRE is supposed to pay you?
No, they have not. And so all they have, what that case is about is whether or not the statutory obligation and the definition of what the net cost of services and net operating budget is defined as, that's what that case has come down to.
And that's
whether or not,
case, right? Judge Gleicher's
yes.
case. Okay.
Yes, yeah, which we argue on the 15th of February, Your Honor. So at the end of the day, the state has said on one side, no, we're not obligated to provide this funding, go get it from Lakeshore. On the other side, they have said, sorry, Lakeshore, you can't pay it, even though as part of the contract settlement in the administrative case, Lakeshore was required to provide a deficit resolution proposal to the state, which they timely provided. The Lakeshore is required to go forward with the LRE plan that was part of that settlement agreement. MDHHS is required to cooperate with Lakeshore as part of that settlement agreement in implementing that plan. They have submitted that proposal. They have submitted as part of that overall obligation to continue to work with the state, they have submitted a proposal, a risk management strategy for the current fiscal year that includes payment of these deficits, and the state is still saying no. And I just can't figure out why the state is saying in one context, go get it from Lakeshore. Lakeshore has done everything it can possibly do to try to comply with resolving this deficit, comply with the settlement plan, comply with the risk management strategy that they have provided to the state, that the state has now approved. And now the state's saying, sorry, you can't pay them. All the while, Muskegon County continues to carry a $12 million deficit that at one point their auditors are going to say, I'm sorry, you can no longer hold this deficit. And that is going to detrimentally greatly impact Muskegon County in terms of its bond rating and all of the ways that Muskegon County is able to continue to get funding for all of the services it provides, not just for mental health care. So this is going to have a grave impact if Muskegon County cannot recover these funds for a service that they were mandated to provide, a Medicaid service. They cannot turn Medicaid, once you start this program, you cannot turn Medicaid beneficiaries away. You have to provide the service. They provided the service, and now the state is refusing to pay for it or allow someone else to pay for it. And at the end of the day, that system is not going to work in the long run. It's not going to provide stability to the region for community mental health services. And it just can't be the outcome of all of these cases.
Okay. Before we go on to Mr. Kavanaugh, Mr. Ryan, I have one question for you. What relief are you asking for? What exactly do you want?
I'm asking for a declaration that Lakeshore would not be in breach of the PIHP contract or law by using funds, ISF funds, current dollars, or Medicaid savings to reimburse the CMHs for the fiscal year 18 and 19 deficit.
Okay. All right. Let me just finish writing that down. Okay. All right, Mr. Kavanaugh.
Thank you, Your Honor. There's a lot discussed, so I'm going to try and take them in the order they were presented.
If you can make it simple, I'd be delighted. But
I will try my best, Your Honor. I want to start more broadly with the purpose of these PIHP contracts to put them in context for the court. So these are year-to-year contracts. They're not multi-year contracts. The current one needs to be renewed every year. So the subject matter of these contracts are on a yearly basis. And under the contract, the state of Michigan is required to provide capitated funds to, in this case, Lakeshore. And what capitated funds are and what we've expressed in our brief, essentially they're estimated prepayments on a monthly basis to Lakeshore to say, we think you have these many Medicaid beneficiaries in your region. This is how much money we think you're going to need going forward to provide services for those Medicaid beneficiaries. So the very outset of the funding is prospective in nature. It's not designed to provide funding for services that have already been rendered. They're capitated payments that are estimating future needs. So that's an important piece of context for the court because it frames the entire purpose of PIHP contracts in the state. They're not retroactive looking, they're prospective looking. And that'll tie into the arguments that I bring up later. But I want to keep that in the court's mind that these contracts are year to year forward looking and estimates on how much money you're going to need to provide services for the number of beneficiaries in your region.
Okay.
The other thing I want to put in context for the court is that Lakeshore alleges that it was solely the state of Michigan's capitated funding in fiscal years 18 and 19 that caused this current issue. That's inaccurate. As we've pointed out in our brief, I submitted on Exhibit E of our motion, Your Honor, the ISF fund is the primary method that that PIHPs can utilize to pay deficits or liabilities that they incur in that year for the contract. In fiscal year 17, Lakeshore was uniquely positioned as the only PIHP in the state of Michigan who didn't have a balance in their ISF fund. They didn't have any net proceeds. That wasn't a result of the state of Michigan's actions. That was years of mismanagement. The state alleges fiscal mismanagement by Lakeshore to the point that in 2019, the state actually moved to cancel Lakeshore's contract.
Mhm.
So I want to point out that Lakeshore was uniquely situated in that they were not financially stable when this occurred. And that's important because, as I mentioned, the primary method for addressing liabilities or deficits is that ISF fund. That's designed in the risk corridor. That's what the risk corridor is, Your Honor. It's basically saying these are capitated funds. They're estimates. They're not perfect. At the end of the year, we're going to settle up. Either you spent less than you received or you spent more. Here's how we handle both of those
All
situations.
right, well, let me stop you there. Okay, let's say they spent less than they received. What does the contract say?
So they spent more on services.
No, they spent less on services.
Yes. So they're able to retain a certain portion of those funds, Your Honor. And that is under section 8. Section 7, the risk corridor section. So
Right.
if you look at A, it actually mandates that they retain certain percentages of those excess funds. It's on page 66, Your Honor.
Yeah, I'm reading it right now, just a second. It must retain unexpected risk corridor related funds between 95 and 100%. I don't know what that means, between 95, and must return unexpected risk corridor related funds to the state between 0 and 90. I don't understand that paragraph one bit.
So my understanding, Your Honor, is if they only spent, let's say they received $1, okay? We'll keep it simple. They received $1 in capitated funds. We settle up at the end of the year. And at the end of the year, it turns out that Lakeshore only spent 90 cents, okay? So there's 10 cents left over.
Right.
My understanding is that the contract mandates that Lakeshore keeps 5 cents, so the 95 to 100.
Mm-hmm.
And then half of basically the other 5 cents that's excess. That's my understanding of the contract. So they'd be keeping 7.5% cents in that. The remainder would lapse back to the state of Michigan. And that's a very simple explanation. There's probably caveats to that, but in a nutshell, that's my understanding of what that means, Your Honor.
All right. And when it says unexpended risk corridor related funds, what are risk corridor related funds?
I would say, I believe they're the capitated funds, the funding that Lakeshore receives.
Okay. All right.
And
So
again,
it's all funding, all capitated.
It goes back to the notion that these are prepaid estimates.
Yeah.
And when we cost settle, it's not perfect. It's unlikely that we're going to hit it right on the nose.
And how much money, if you know, or tell me the mechanism that money is placed in the ISF?
My understanding of the ISF is that the PIHPs are permitted on a yearly basis to retain up to 7.5% of funding to fund their ISF for future liabilities. So in my
That's
instance,
different than the 7.5% we just talked about.
that's what they're required to keep under the contract.
Is 7.5% per year they're supposed to put into ISF? Is that what you're saying?
They're permitted to.
Oh, okay. Okay.
So in our scenario, the 7.5% cents would go, they would be permitted to put that in an ISF so that in the following year, if they're 7.5 cents short, there's a deficit, they can use their ISF that they banked to pay that.
So the 7.5% that you talked about as being retainable under section 7A, is that the 7.5% that can go into the ISF, or is there another 7.5%?
That's my understanding, Your Honor.
Which one? I didn't get it.
I'm sorry that they could use capitated funds or any other source funding, sources of funds. And I just want to note that other sources, potential sources, are local funds. So counties and municipalities, it's my understanding, or CMHs, I'm sorry, can contribute. Those are local contributions. That's another source of potential funding. And then separate appropriations to that PIHP are also potential sources of funds. So the legislature actually appropriating additional money outside of the Medicaid funding.
So I want to hear everything you have to say, but at this point, so who's supposed to pay these providers? Anybody? And if it's Lakeshore, how are they supposed to get the money?
So the services are to be provided by the CMHs. The primary source of funding is the joint program run by the state of Michigan and the federal government in the form of capitated funds. How they pay for that are through the capitated funds. And if they're short in the following year, the contract provides the ISF mechanism to make up the difference.
Right, but in this case, let's say you win the case, does Health West get their money? And if so, from whom and how?
So I can't speak to that. All I can say is that it's the state's position that Lakeshore put itself in the position to not have the funding required in 1819 because it didn't have an ISF balance to cover those deficits. And they're now retroactively trying to pass that liability onto the state. The state already provided a mechanism in 18 and 19 for Lakeshore to pay off potential deficits. That's
Well, what the money is that the money in the ISF presently, what is the state's claim to that money? If it's money that didn't have to go back to the state at the time it was put in the ISF.
that money wouldn't lapse back to the state, Your Honor.
So why can't they use it?
Because the contract prohibits the ISF from paying historic deficits, and that's in
And why would that be a problem? I mean, I think must be some rationale of, I appreciate the contract, but I feel like there must be some underlying rationale of the state that I'm missing, but perhaps not, as to why they say this would be a harmful outcome other than our contract says something else.
Because it could incentivize other PIHPs to not properly fund their ISF or be in a fiscal position to pay off their deficits. And then years later, come back and say, hey, state, we didn't have enough money because we didn't save it. Let us use the money that should return to you to pay this. That's the gist of the state's position, Your Honor, is that it incentivizes PIHPs not to be in a fiscally sound position when those deficits occur as they're supposed to.
That makes sense to me. Now tell me what monies that they want to pay to Health West and other providers would otherwise come back to the state.
So it's outlined in the contract, Your Honor. It's basically any excess above 90%. So in our scenario, anything over the 7.5 cents, really.
Let me hang on. I got to stop you. Say any excess above 90% of what?
The capitated funds received. So in our scenario, if Lakeshore got $1 and they spent 90 cents for the year,
Okay,
there's a surplus of 10 cents there.
right.
The contract says Lakeshore, you have to keep 5%. You keep an additional 2.5 cents, and
Right.
then the remainder goes back to the state of Michigan. So in our scenario, it's
Which
really
would be 2.5 cents, right? Because above
Correct.
that, then the state does pick it up.
correct.
So but it gets me back to my question. What's in either the ISF or the Medicaid surplus or wherever they want to pay this from that you say belongs to the state?
In this current,
Yeah,
if it's within the 7.5% limit, it would not lapse to the state, back to the state. Those funds would be necessary to pay potential future deficits in future years. That's why those funds are there.
Okay. So I'm sorry to be thick.
That's
But
fine.
So are you saying that monies have been put into the ISF that should have been refunded to the state?
No,
Are you saying that there's something called Medicaid surplus funds that they've held that should have been returned to the state?
any surplus funds that exceed that 7.5% would lapse back to the state. So if in the event that they fully funded their ISF to the 7.5%, those remainder funds would lapse back to the state.
Whew, I got to tell you. Okay. All right.
It is complex, Your Honor.
All right. Well, keep going.
Okay, so the point I was trying to get to is that Lakeshore was uniquely situated as a fiscal year 17 as being the only PIHP without an ISF positive balance, which led to this issue that we're here today.
But does fault matter? I mean, whether the state wasn't paying enough or whether they screwed up their management or both, does that change what the outcome of this case?
I don't think it would, Your Honor, because at the end of the day, if they were functioning properly, they would have an ISF reserve that would have addressed the deficits they encountered in fiscal year 18 and 19.
Right, but that doesn't, how is that relevant to the issue of whether they can now use the monies they want to use?
Because
Who's fault it was?
they're asking this court to declare that the ISF can be used to pay those deficits that they incurred in 18 and 19. That's not what the ISF is designed to do. It's designed to pay future deficits. We've raised the claim, the arguments in our brief, and I'm happy to walk the court through those provisions of the ISF.
Please do. I'm sorry for taking so much time for all you folks, but this is my one shot to get.
That's
answer.
quite all right. So on page 65, I believe it is, of the contract,
Mhm.
that outlines the terms for the ISF.
Right.
And as we pointed out in our brief, the ISF is the main method that PIHPs use to address liabilities that are incurred on the year-to-year contracts. So the provision B there, Your Honor,
Yes.
is an ISF may be established for the purpose of securing funds necessary to meet expected risk corridor financing requirements under the contract. The word expected is not defined in the contract, but it means looking for the future occurrence of. It means,
Well, if I owe somebody $100 and then I borrow another $100, isn't there, at that point, doesn't the lender have their expectation when they make that second loan is that there's a $200 shortfall, that they're owed $200, not $100, right? So why can only future things be expected if the circumstances of that future may be dictated by past events?
because I think I understand, Your Honor. I would just say because the debt was incurred in 18 and 19, it can't be expected if you've incurred it and now have a surplus of funds.
I understand your argument. I'm not sure I agree, but continue. And I think you have a strong argument on the risk
So
corridor section.
the other thing that I would note, Your Honor, is in that paragraph 4, subparagraph G.
Yes.
It expressly states that Lakeshore must restrict the use of the ISF to the defined purpose. And the defined purpose is on the next page, Your Honor, in section 7.
Okay.
And that's specifically J1, Your Honor. So it's towards the bottom of page 66.
You said J1?
Yes, Your Honor.
Okay, 7.J.1. Okay.
And it
And
says,
I'm looking at it.
it reiterates Lakeshore must restrict the use of the ISF to the defined purpose. And then it expressly defines what that purpose is, Your Honor. It says the purpose of the ISF is to secure funds necessary to meet expected future risk corridor requirements. It's plain, it's unambiguous, Your Honor. The ISF is designed to address future liabilities, not to pay historic deficits that were incurred nearly 5 years ago now. Mr. Ryan brought up the fact that this provision wasn't in the ISF paragraph. I would again direct the court's attention to that subparagraph G in the ISF provisions, which expressly states that Lakeshore must restrict the use to the defined purpose. The other thing I would note, Your Honor, is this isn't a statute. The contracts are read in their entirety and given meaning to the entire contract. So this court is actually prohibited from selectively choosing one provision to focus on while ignoring the other provisions. So I don't think there's any weight for that argument. The court should disregard what the contract expressly defines as the purpose for the ISF.
So I probably asked you this already, but let's say you prevail here. Is Health West going to get paid? And if so, by whom?
I don't know if I can answer that, Your Honor. I don't have.
Well, it's an important question to me.
I agree, Your Honor. All I can say is that the obligation was on Lakeshore to have sufficient reserves in 1819 at the time the debt was incurred.
Well, it doesn't sound like your office is very concerned with the stability of the system. And that is part of the contract, that these monies are to be used to maintain a system in which poor people can obtain Medicaid benefits. So, I mean, if you're saying there's a crisis, but we're not interested, how does that help?
I guess I would just note again that there are other sources, potential sources of funding available,
So you're saying the county should pick it up?
or a separate legislative appropriation is possible. I can't speak as to what
Okay,
the legislature or the local governments are going to do.
okay. All right, more on the contract. You want to move on to these post-contract documents?
I'd like to address the surplus argument.
Yes.
So Lakeshore is saying that these excess funds or surplus funds, there's nothing in the contract that prohibits them from spending it on historic debt. And they cited that provision specifically, Your Honor, on the bottom of page 69, top of page 70 that you went over with Mr. Ryan as
Give me
the
a
basis for using those surplus funds.
Bottom of page 69.
Yep, to the top of 70, Your Honor.
Got it. Okay. Uh-huh.
So the first thing I would know is that the contract expressly requires Lakeshore to return surplus funds based on that risk corridor provision. And that, Your Honor, is in paragraph 7, the risk corridor.
Hold on.
Or I'm sorry, yeah, 7A.
7A. Okay.
And it's the last sentence. The contractor must return unexpended risk corridor related funds to DHHS. That's the 2.5 cents that we're talking about, Your Honor, in my hypothetical.
Okay.
So the contract expressly requires them to return these funds to the state of Michigan, or for those funds to lapse back to the state of Michigan. Lakeshore asserts that, in their brief at least, that these aren't unexpended funds because we want to use them to pay off Medicaid services. And really, the Medicaid services that they're referring to are actually liabilities because they were incurred in fiscal year 18 and 19. It's not like they're going to go out and pay to have a service performed prospectively like the contract is designed to do. They're liabilities. And with respect to that provision on the bottom of page 69, Your Honor, which Lakeshore relies for its argument, it says that surplus funding in either Medicaid or Healthy Michigan may be utilized to cover a funding deficit only after that fund source's risk reserve has been fully utilized.
What's a risk reserve? Is that ISF?
That is the individual fund. So there are two separate funds. There are two giant sources of, if you will, the Healthy Michigan and then the Medicaid is what we've called it in our brief. And to cut to the chase, what this paragraph is explaining is that after a year, if you have a deficit in your Healthy Michigan fund, but a surplus in your Medicaid, you can use the Medicaid to balance the Healthy Michigan fund. And then if you're still at a deficit, then you go to your ISF.
Okay, so it's saying you can use surplus funds from Medicaid for Healthy Michigan or vice versa.
Correct.
And only when that's depleted can the ISF for the relevant half, part of it, be used.
Yeah. And the key point in this provision, Your Honor, is the last sentence there is the surplus funds must be used before the ISF can be utilized. And why that it's important is because if this court accepted Lakeshore's interpretation that it meant that it had to first use surplus funds to pay off its liabilities, that would be in direct conflict with the ISF, or excuse me, the risk corridor provisions that says that the ISF has to be used first to pay liabilities. You would have two directly conflicting provisions in the contract. One that says you got to use surplus funds first to pay liabilities, and one that says you got to use the ISF first to pay liabilities. Courts are required to harmonize where reasonable.
But there are no surplus funds, are there? I mean, relevant to 2017, 2018.
No, and we're not talking, at least my understanding is Lakeshore is not talking about using surplus funds from 18-19 because there were none. They're talking about using the 21-22 surplus funds.
Right, but I understand, but your argument about you can't use this stuff to pay for the past, that's overarching. It doesn't matter what order anything can be used in this provision. The point is you say none of it can be used.
That's correct, Your Honor.
Okay.
So, I mean, the court touched on this point in its questioning of Mr. Ryan, but if the court were to accept Lakeshore's interpretation of that provision bottom of 6970, that would directly conflict with the language in the ISF risk corridor that requires the ISF to be used first to pay liabilities.
Okay, I just want to make sure I have. Okay, in the risk corridor, tell me again, where's the provision that you say is in conflict?
If you can give me one moment, Your
Is it
Honor.
H, 7H?
I believe that's correct, but I'm going off my memory. So if you can bear with me, I'll look and
Yeah,
confirm.
it's
that
on
for you.
page 66, I think.
That's correct, Your Honor.
Okay. And how do you harmonize them?
The paragraph at the bottom of page 69, Your Honor,
Yes.
about using the surplus, that's referring to balancing the Michigan Healthy, the My Healthy, and the Medicaid funds that the PIHP has internally on a year-to-year basis. That's talking about essentially a current year balancing of those funds.
Okay,
You use it vice versa to balance, and then if they're both negative still, you go to your ISF. Whereas if you had a deficit in My Healthy Michigan and Medicaid and a surplus in Medicaid, you could
could move
potentially offset it so that you don't have a deficit in either one and you wouldn't have to go to the ISF. That
okay.
is the department's interpretation.
Okay.
And I believe it's reasonable and it harmonizes what would otherwise be directly conflicting with that risk corridor subsection H that we previously identified.
Okay. Are you ready to talk about the post contract materials, the settlement, the risk management plan, and so on?
There's one other thing for the contract, Your Honor, if I might. The use of these Medicaid savings funds. So Lakeshore filed this action to ask the court to affirmatively state that it can use its Medicaid savings fund to pay historic liabilities. As was mentioned earlier, the fiscal year 19 contract contained provisions permitting LRE to establish a Medicaid savings fund, and then the restrictions on the use of those funds.
And where is that?
That was in the fiscal year 19 contract, and that was attached as an exhibit to our
Okay.
motion.
Is this
Your
the
Honor.
thing that was in and then it came out and now you want to put it back in?
That's correct, Your Honor.
Okay.
So under Lakeshore has identified no provision in the current contract that even permits them to have a Medicaid savings fund. There is nothing in the contract that says you can save up to 7.5% of funds for a Medicaid savings funds. That's what was in the previous fiscal year 19 contract. It expressly stated you can keep up to this amount of funds in a Medicaid savings fund. That is absent from this contract, Your Honor. So
you're saying under this contract, you can't do anything with something called the Medicaid savings fund.
It doesn't permit them
The
to.
amendment is accepted as now has been demanded.
Correct. And Your Honor, the contract contemplates establishing methodologies to address risk, the primary one being the ISF. So it does have a method. A Medicaid savings fund is not a method that is identified in the contract. Lakeshore has pointed to no provision that permits them to hold those funds and establish a Medicaid savings funds. To the contrary, that provision that I showed the court requires Lakeshore to return unexpended funds over a certain threshold back to the state. I think that concludes the contract. I'm happy to go where the court wants to next, which.
Okay, well, tell me about the risk management strategy and why that doesn't change, favor the plaintiff.
Sure. You can give me one moment. I think for that, Your Honor, I would draw back to the context of the contract, specifically with the fact that it's about the use of capitated funds and what the purpose of those capitated funds are. The capitated funds, like I said before, are prepaid payments to estimate future services.
Mhm.
So placing the risk management strategy in that context, the liabilities that the risk corridor is intended to address are for the future liabilities that are incurred. In this case, a deficit.
But it says historical deficits, that it says they're working to develop a plan to utilize approximately 22 million within the current fiscal year, or to utilize it to settle historic deficits with affiliates, or will lapse back to MDHHS.
Correct. Your Honor, I guess the only thing that I would note is that the contract requires the RMS to be provided to address the current year liabilities. That's in Schedule E of the contract, Your Honor, which
Okay.
outlines when the risk management strategy needs to be submitted. It specifically states that the risk management strategy is to address the current fiscal year. Again, these liabilities aren't from the current fiscal year. They're from fiscal year 18 and 19. So the fact that Lakeshore submitted something that had one sentence that said that they could pay historic debts, I don't think negates the context, the purpose, and the language of the contract.
Also, can you talk to me about the proposal to resolve the historical, this document that has the little chart here at the end that says where the monies are going to come from to pay the historical debt.
Are you referring to the settlement documents, Your Honor?
I think this was part of the, well, I'm not sure. I'm holding up Appendix B. That's part of the settlement, right?
Yes, Your Honor. I'm just trying to trace, is that from Health West's?
I don't really know anymore. to tell you
If I can just offer, this,
Please.
Mr. Kavanaugh, I believe it was attached to Health West's response or concurrence, if that helps.
But and Mr. Ryan, was this attached to the settlement? I think this came, I don't know. Did it come later?
I believe so. I believe, yes, I believe it was a part of the settlement. If I'm
You think this was
saying
part
it
of it?
right. Yes, Ms. Gabus,
But it
maybe you
says
can
Exhibit
chime in because
C on
you
it, but I
attached
don't
it.
know.
But,
Pardon?
sorry, I was just seeing if Ms. Gabus could maybe shed some light on it because I believe it was attached to her filing.
Yes, certainly. So our concurrence included that the LRE plan that was attached to the settlement agreement in the administrative case, the settlement agreement requires Health West requires Lakeshore to follow the LRE plan. The LRE plan referenced the submission of a deficit resolution proposal by April 21st, I believe, or April something of 2021. And what is attached as the deficit resolution proposal is that April 2021 submission that was
Right.
provided to the state.
Can you tell me where in the settlement I'll find? If you don't have to search if you don't know, but I'd like to know where this exhibit is referenced in here, or the plan to have such a thing.
So let me get it up on my screen, Your Honor. The settlement agreement referenced the LRE plan, which I
Right.
believe was like Exhibit
B.
Appendix B to the plan. And then
Attachment
if you look at, I believe it's on page 2 or 3 of the plan, on the right-hand side of the page, it looks like there's like almost like a table, but it doesn't have lines in it. On the right-hand side of the page, it says Health or Lakeshore shall provide a deficit resolution proposal, and there's an April 21st date.
Hold one moment.
Yeah.
Which page do you think it's on? One.
I am going to. Okay, I have it in front of me now. So it is on the LRE plan. It is on the second page of the Appendix B LRE plan.
Uh-huh.
On the second page, item B, completed to MDHHS by 4/15/2021.
I don't see that. I must be looking at it, the wrong page or a different document, or maybe I'm missing it. Hang on, let me-
I'm sorry, I don't mean to interject, but I think there may be, this is a abridged versus unabridged appendix problem.
ah,
That's my suspicion anyway, but I'm trying to look up the unabridged appendix to see if my suspicion is right.
So I would have included in the unabridged all the necessary pages. So if you, I wish I could share my screen.
So you're telling me there's something in here that refers to an April deadline to provide a proposal to resolve the deficit?
Yes, so if you look at the LRE plan, it just says Appendix B at the top, LRE plan.
Right.
And then if you go to the next page,
Let me tell you what, my next page, the first thing under objectives is strengthen the relationship with provider community. So am I missing something?
yes, I might,
Well, that might be my fault. Okay,
I don't know if I'm allowed to share my screen. I could show you right where it's at if I could do that.
I don't know if you can either, but does it have a heading? That would be helpful. What does it say? Is it part of the objectives or delivery date? Which column will I find it?
You would find it under delivery date range,
Uh-huh.
and it would be under, there's an A, a B, and a C.
Uh-huh.
And it would be under B, completed to MDHS by 4/15/21. And then when you go, to the middle column, it says provide a formal deficit resolution proposal to the state by April 15th, 2021.
All right. Thank you very much.
You're welcome.
All right. So, Mr. Kavanaugh,
Your Honor.
so tell me about your position regarding the April 21 proposal and the risk management strategy documents that was approved on 3/29.
Certainly, Your Honor. So the first thing I would note is that the deficit in attachment B that you were just looking for,
Uh-huh.
that was part of the settlement that was stemmed from the administrative hearing to cancel Lakeshore's
Right.
contract in 19. And it's my understanding that the parties deliberately did not contemplate resolving the financial deficits of Lakeshore's debt to the CMHs as part of that settlement, and actually actively removed.
Certainly out of the release. Yeah.
Yeah. So, and I wasn't part of those negotiations, so I can't speak firsthand, Your Honor. I believe Mr. Ryan was, but it's my understanding that the contemplation of how Lakeshore would resolve those deficits from what sources was not part of the settlement agreement. The other thing I would note is that the LRE plan merely provided for Lakeshore to provide that document to the department, not to approve that document. It says that they provided it to the department by the date that it was due. Doesn't speak to waiving or consenting to that that plan. So I think that's all I have to say with respect to that document, Your Honor.
The April document.
Correct. And with respect to the RMS that was submitted as part of Lakeshore's brief, I think we touched on that earlier, but I'm happy to reiterate if you'd like.
Yeah, just tell me again, your position is that this doesn't really say that they're going to use that money, pretty much?
Our position is the contract doesn't contemplate nor allow the use of those funds to pay historic debts. And
Well, then the question is, why wasn't that addressed when this was approved?
I can't speak to that, unfortunately, Your Honor. I don't have that answer today.
Well, given that it was approved, what do you think I ought to do with it?
Well, I believe that I think the contract would control, Your Honor, and I think I've spoken to why the department's
Yes, you have.
position on why the contract doesn't permit that.
Okay. Anything else you want to cover, Mr. Kavanaugh? You want to say anything about the statutes or the regs or?
The only thing that I'll address is the regulation that was covered with Mr. Ryan with respect to the state directing payments.
Uh-huh.
The state is not directing payments. What that CFR refers to, Your Honor, is the state of Michigan interjecting itself and saying, Lakeshore, pay this CMH this amount, this specific amount.
Mhm.
The state concedes they're prohibited from doing that because it's up to the PIHPs to contract with the CMHs to determine how best they want to provide those services. That's not what the state is doing here. They're not directing payment to a CMH. They're merely enforcing the contract as written, which prohibits the use of funds to pay historic debts. So I don't think there's a conflict with the regulation, Your Honor. On top of that, all PIHP contracts are approved by federal CMS, Centers for Medicaid and Medicare. And there was no objection to what clearly expressly in the ISF prohibited, and our argument that the contract as a whole prohibits payment for historic debts. There was no objection. This contract was approved by CMS. Its existence, proves that CMS approved the contract. So I don't think that the state's arguments or intended course here directs payments and conflicts with that regulation.
Okay. That it?
That's all, unless the court has some other questions.
No, but I want to offer Mr. Ryan and Ms. Is it Gabis? I'm sorry.
It's
An
Gabus.
opportunity.
Thank you, Your Honor.
Gabis? Thank you. I want to offer them an opportunity for a rebuttal if they want.
Just real briefly, Mr. Kavanaugh started out by saying that one of the whole purpose of this contract is to fund future services and that it's very forward looking. Again, I would challenge the state to point to any provision of the contract that actually says that. I understand that that's what their argument is, but the contract just doesn't say it. I think
If
it's
Mr. Kavanaugh, you would concede there's no explicit provision that says you may not use this for past, but there's stuff that you pointed out that says it can only be used for future.
Correct, Your Honor. And then
Okay.
if I may, Your Honor, the only other provisions really are the capitated fund provisions, and those are on page 68, Your Honor, that
Mhm.
speak to how the funding works under this contract and the prospective nature of it. But I agree, I will concede there's no express provision that is directly on point
Okay.
that says thou shalt not use any funds for historic. I think I've made our arguments for why the context says that.
And is that in the new contract provision that's being now put in by DHS? Is there an explicit, the
Yes.
return of the Michigan Savings Plan with now some limits?
That's with respect specifically to the Medicaid Savings Fund.
Medicaid Savings Plan, that's okay. All right, thank you. All right, Mr. Ryan, I'm sorry I interrupted. Go ahead.
No, that's okay. So just so we're clear on that last point, Lakeshore has not, that amendment is not part of the contract. Lakeshore has not agreed to it. I just want the court to be clear on that. So one of the other major points that Mr. Kavanaugh made was that Lakeshore was in this position because of mismanagement, et cetera, et cetera. And I think the court acknowledges that really those arguments are irrelevant. I'm not going to get into all the reasons why we disagree with that, but here's the important part to take away is that as Mr. Kavanaugh acknowledged, the state places an artificial cap on the amount of money that Lakeshore is allowed to put into the ISF, 7.5%. We're not allowed to put any more than that in. So if their argument is that the ISF can't be used to fund historic deficits, what is a PIHP like Lakeshore or CMH like Health West to do if the services in any given year grossly exceed that 7.5% cap? In other words, there's no recovering ever from it, because if the services are 30% more than 7.5%, you're going to exhaust the ISF, which is capped at 7.5%, and you're never going to be able to recover.
Doesn't the ISF compile over time?
It does, but it capped out. It's every year you're only allowed to put in 7.5%, so it creates this artificial ceiling. So if the services grossly exceed that amount for a year or two, as it was in this case, it's going to bottom out, and there will never be, according to the state's logic, there is never a way to recover from it. And so I don't think it's really accurate to say, oh, well, Lakeshore is just in this position because of their own doing. I mean, it's way more complicated than simply that. I think there was an argument that, well, CMS approved the contract and therefore it can't violate, federal law. I think even if that were true, if CMS approved the contract, CMS approving the contract is much different than, well, CMS approved it and therefore they must agree with the state's interpretation of the contract.
Does CMS place the 7.5% limit, or is that just contractual?
No. CMS does not place the 7.5% limit. The state places the 7.5% limit. I think that's it. I think the court hit the nail on the head with regard to asking the question of how is Health West going to get paid if the state prevails here. And the answer is, I have no idea how they'll get paid, or if they would ever get paid.
Okay, Ms. Gabus, did you want to add anything?
Briefly, Your Honor, just to a couple of points, and I'll keep it short. In Mr. Kavanaugh's argument, he indicated that the funds would lapse back to the state if they aren't used for the purposes that Mr. Ryan is promoting. So the question being, then, if these funds lapse back to the state, is the state then going to turn around and pay Health West? And Mr. Kavanaugh had no answer to that question. But I will posit to this court that the answer has been provided in the Court of Appeals. Absolutely not. They don't intend to pay Health West at all. And I would just like to highlight for this court that it is not Health West, it is not the county, it is not Lakeshore that is constitutionally mandated to support mental health services or statutorily mandated to fund the mental health services. It is the state. So regardless, and when we speak about this so-called fault of Lakeshore, no fault of Lakeshore, I think Your Honor hit the nail on the head that the fault is irrelevant. For one, that issue has been closed. They litigated that case in the administrative hearing. They settled the case. There's no finding at all that I'm aware of that Lakeshore mismanaged anything. My impression, at least for what it's worth, is that there just wasn't enough money. There just wasn't enough money for the amount of mandated services that were to be provided in those fiscal years. And Mr. Ryan makes an excellent point. When there is a cap on the amount of money that you can put in an ISF fund, and there is year over year just not enough money, or if there's no surplus at all, then there will never be enough funds to make up those deficits. And it is not the county's responsibility or Lakeshore's responsibility to hold that burden. It is the state's responsibility to hold the burden of providing funding for mental health services for a vulnerable population. Lastly, Your Honor, what I would just like to hit upon is, and I don't think anyone has touched upon this argument, whether the contract says this, whether the contract says that, if there is a contractual provision that is void because it violates public policy, then this court can ignore it. This court can set aside the contract and that provision. And that is exactly what will happen here if these contract provisions are read to the result that the state would like this court to employ, which is, we don't know how Health West is going to get paid. And
but what's the source of the public policy?
I'm sorry, Your Honor.
What's the source of this public policy?
Stability.
So find.
Yeah. So the stability, maintaining the stability of mental health services in a vulnerable population. It is gravely important that this court uphold the constitutional mandate that should be supported. And if it comes down to a result where a community mental health agency such as Health West, that's 80% of its budget relies upon the funding from the state, and if they are required to absorb a $12 million deficit year over year over year, they will shut their doors. They will have no choice. Sure. There will be no mental health services for a population that otherwise can't afford it. And the detrimental result of that on the community as a whole is significant. and it just can't stand. And so when you're looking for a source of public policy, there it is.
Well, does the Muskegon case address these constitutional provisions, doesn't it?
Yeah, the Court of Appeals case, Your Honor, that's pending.
Yeah, the one that Lakeshore decided.
Yes, it does.
Okay. All right. So will you finish?
I am. Thank you, Your Honor, for the opportunity.
Sure. Thank you. So I two questions. One is, I do want a glossary and I'll send an order out. How long do we need? Is 7 days enough or you want more time?
I think
If-
7
if you-
days would be sufficient.
If you want Mr. Kavanaugh and Ms. Gavis and I to get together and perhaps agree on them, is that the court's? Is that what the
That's
court's
my
in
hope.
mind?
If you can't agree on certain ones, then you'll submit two, I guess.
I mean, I think we may need a little bit more time than 7 days if we want to get together and agree on it. And I think I suspect that the three of us can agree on the vast majority, if not all of these.
Okay, 14 days enough?
Sure, I think so. And we'll get it early if we can.
Sure, thank you. And then last question is, what is the respective positions on whether you want a decision before or after the Muskegon case is decided? Or don't you care?
I mean, I leave it to the court's discretion of when they're going to issue an opinion. I think that, it has the potential to resolve the appeal, of course. And I would just note, I think Your Honor hit on it, that this constitutional public policy argument was raised and rejected by this court. So I think that's worth noting. But I would honestly, Your Honor, leave it to the court's discretion.
That's fine.
Yeah,
Mr. Ryan, do you have a preference?
Well, I mean, so in thinking it through, I think that if the court, I mean, obviously, if the court grants the motion, it's essentially going to moot the Court of Appeals case. I suppose that if there are issues that the court, related to the constitutional issues in the Muskegon case that the court would want to take into account, then that's,
I don't see how we can moot out that case since this is going to be appealed, I imagine, whatever I do. Maybe not. But,
I'm sorry,
Go
I
ahead.
did not want to interrupt you. We would absolutely prefer a response before the Court of Appeals case, because to the extent you rule in favor of Lakeshore and intervening plaintiffs, Southwest in this case, then that would absolutely moot the Court of Appeals case. It would moot the Ottawa County case. It would save our client a whole lot of money that they continue to expend in litigating these cases in multiple venues. And so we would absolutely prefer that. And I think a 7-day deadline is fine for Southwest to collaborate and get you the glossary of terms so you can do your attempt to get us a decision before then if possible. I don't want to rush the court, obviously, but
no, I
in
understand.
the interest of justice, we certainly would prefer it beforehand.
All right. Well, today is the 23rd, right?
Right.
And so how about if you get me, can you get me a glossary by February 3?
Sure.
I think
Absolutely.
that's sufficient time.
So it's just short of 14 days.
Yeah.
Okay, very good. So that's what we'll do. But I will be working on an opinion and we'll see when it gets done in relation to the other one. I'll do my best, but we'll see. Okay. Any questions or concerns? Go ahead, Mr. Ryan.
I was just going to say, I think I wrote down all the terms of the glossary, but is the court still going to issue an order for exactly?
Yes,
what
I
terms
will
it
do it
wants?
today.
Okay. All right. Fair enough.
Thank you, Your Honor.
Any questions? Anything else? All
Thank
right.
you.
Excellent. Thank you all for your time. I know this was lengthy and we'll do our best to get an opinion out promptly. Thank you very much.
Thanks, Your Honor.
Thank you.
Sean,
Yes,
can you get me the audio of this to my email just in case somebody orders?
yes, I believe I can do that. I'll contact our IT department.
Okay, great. You have my email, I think, don't you?
I'm sure Angela has it.
I was gonna say it was required to put it in there to sign on to this meeting. If not, I can give it to you right now.
Yeah, that'd probably be easier. Let me
Can I
stop the
put it in
live
the-
stream so you're not
Okay.
sharing your email with the
Okay,
internet.
okay.
One second.